In this video, you will be presented with the option provided in federal tax statutes created by the U.S. Congress to terminate or revoke the election that was made by most all American nationals at one time in their lives. Many American nationals will initially meet this information with disbelief and perhaps denial that such could be true. Resistance to any new idea, especially one that is unexpected and one that has the potential for a huge impact in your life, is very normal. Fear of the unknown is the initial reason for the resistance in the majority of the people who are seeking such validation of new information that runs contrary to their prior understanding. Sometimes conditioning to the status quo is ingrained so heavily that it takes some time to get past the propaganda and presumptions that is present in your mind at this moment. We invite you to simply review this video and keep your mind open to the new paradigm shift that is now before you. The background for this subject has been prepared to be a short one, as a more detailed explanation is found in our YouTube video on jurisdiction. This video is available within our resource center on our website, Weiss+Associates.com. Perhaps now is a good time to present a general overview of terms, and then we'll move forward with the explanation pertaining to the aspects of the revocation of election that is an option for American nationals. For most Americans living and working in the private sector in the constitutional republic, the 50 states of the Union, they think the actual law that imposes the federal income tax is directed at the 16th Amendment. What is not considered by the majority of those who think in this manner is the aspect of jurisdiction for the application of those special laws found in the Internal Revenue Code, which resulted from the 16th Amendment. At this time, let's go back in time, when the U.S. Constitution was ratified for the fledgling nation. One of the foremost thinkers of his day was Alexander Hamilton. He was a critical thinker, and history has shown he was preparing for the eventual separation of the original 13 colonies from the British Crown. He wrote his thoughts and ideas in a publication entitled The Federalist Papers. In the Federalist Papers, number 15, written by Hamilton, the first Secretary of the Treasury, he stated in part, "Except as to the rule of apportionment, the United States has an indefinite discretion to make requisitions for men and money, but they have no authority to raise either, by regulations extending to the individual citizens of America. The consequence of this is that, though in theory their resolutions concerning those objects are laws, constitutionally binding on the members of the Union, yet in practice they are mere recommendations, which the states observe or disregard at their option." Here you see his reference to the rule of apportionment was a key component for the United States, meaning the national government, to adhere to regarding its request for men, military personnel, and money, taxation. He basically states that if the rule of apportionment is not considered, then the United States, the national government, can ask for men and money from the states, but that the national government has no authority to raise either, by regulations extending to the individual citizens of the constitutional republic. So, to summarize Hamilton's discussion in this context, we see that the national government has no power or authority to create any regulations directed to the individual citizens of America unless it uses the rule of apportionment first. Now, let's reflect on the wording of the 16th Amendment. We have a copy of it posted in our Resource Center, as it was published by the Government Printing Office, and on page 2 of that document, you find the 16th Amendment along with the history and purpose of the amendment. Here is the actual wording. "The Congress shall have power to lay and collect taxes on incomes, from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration." Did you see the reference to without apportionment? This is what Hamilton was discussing in his Federalist Papers number 15. Therefore, one can easily conclude that the national government has no authority to raise money via taxation by regulations if the national government was intending to direct an income tax toward the individual citizens of America within the constitutional republic. Can you see that? In the history and purpose section of this document, you find, "The ratification of this amendment was the direct consequence of the court's decision in 1895 in Pollock v. Farmers Loan and Trust Company, whereby the attempt of Congress the previous year to tax incomes uniformly throughout the United States was held by a divided court to be unconstitutional. The United States Supreme Court stated in the Pollock v. Farmers Loan and Trust Company decision that to avoid the inclusion of the rule of apportionment, just like Alexander Hamilton stated, was unconstitutional, meaning that the national government has no authority by regulations to levy that tax upon the individual citizens of America. The wording on the 16th Amendment was derived from former President William H. Taft in his creation of the legislative intent of the 16th Amendment. This is the foundational document behind the 16th Amendment, and most American nationals have no awareness of its existence. This document was promulgated in an obscure area of the government archives where most Americans would not think to look. Weiss+Associates located this document many years ago in the original research to locate the legislative intent behind the actual amendment. This document was posted in July 2013 on our Resource Center, and it was obtained from a request approximately 15 years ago from a representative following a search by the Congressional Research Service. It was published in the Congressional Record of the United States Senate on June 16, 1909 on pages 3344 and 3345. You can also request your own copy from your elected representatives in Washington. The Pollock v. Farmers Loan and Trust Company was the U.S. Supreme Court decision pertaining to the attempt by the U.S. Congress in 1894 to levy a federal income tax directly upon American nationals without regard to the rule of apportionment. President Taft stated in part that the Pollock v. Farmers Loan and Trust Company case was held by a Supreme Court to be a direct tax, and therefore not within the power of the federal government to impose, unless apportioned among the several states according to population. Shortly following this statement, Taft added, "The decision of the Supreme Court in the income tax cases deprived the national government of a power which, by reason of previous decisions of the court, it was generally supposed that government had." With great emphasis in the same paragraph, Taft went on to state, "I therefore recommend to the Congress that both houses, by a 2/3 vote, shall propose an amendment to the Constitution conferring the power to levy an income tax upon the national government, without apportionment, among the states in proportion to population." For the first time in American history, the national government created an amendment that impacts only the District of Columbia and its territorial extensions. As you recall from Alexander Hamilton's commentary in the Federalist Papers, Article 1, Section 2, and Section 9 of the U.S. Constitution, and the decision of the United States Supreme Court, the national government could only lawfully bypass the requirement for the rule of apportionment if such a legislative act of Congress did not apply to the constitutional republic. Thus, there are two separate and distinct jurisdictions that exist by ratification of the U.S. Congress. First, there is the constitutional republic, the now 50 states of the Union, and secondly, the sovereign territorial jurisdiction limited to the District of Columbia and its U.S. territories. For more information on jurisdiction, please review our YouTube video on that subject. Federal Attorney Michael L. White, holding a public office in the Office of the Federal Register, has stated in his legal opinion letter on behalf of the national government, in the last paragraph of his letter to an American national in Cicero, Illinois, on May 16, 1994, that our records indicate that the Internal Revenue Service has not incorporated by reference in the Federal Register a requirement to make an income tax return. The Federal Register is the legal newspaper, if you will allow that term, to let American nationals know of the existence of any laws in the form of an implementing or legislative regulation that meets the litmus test of the Constitution that a new law is applicable within the constitutional republic. It references such legislative regulations by volume, date, and page number of the publication of that law in the Federal Register. The regulation at 26 CFR section 601702A1 addresses the requirement for publication of all laws by any federal agency or bureau to be published in the Federal Register. Then, further down in that regulation, at 26 CFR sections 601702A2II, one finds the reference to effect of failure to publish obligations in the Federal Register as required by the Federal Register Act, 44 U.S.C. Chapter 15, where it states in part, "Thus, for example, any such matter which imposes an obligation and which is not so published or incorporated by reference in the Federal Register shall not adversely change or affect a person's rights. The reason that there are no implementing or legislative regulations pertaining to the federal income tax that would be applicable within the constitutional republic has already been addressed. This is a further confirmation by a federal attorney of what has already been presented. The 16th Amendment does not apply toward American nationals, lawful non-taxpayers in the constitutional republic. The 16th Amendment would have been removed by the Supreme Court if the national government had once again attempted to levy the federal income tax upon American nationals. It is fine as written, due to the limited jurisdiction in which it was only made applicable toward. The impact of two distinct jurisdictions is the key for understanding the proper application of the 16th Amendment. As a side note opinion, there are those who contend that the 16th Amendment was never properly ratified. However, due to the limited jurisdiction to which that amendment is only applicable within, we feel that such a position is a non-starter due to the limited jurisdictional application of the amendment. With the understanding of the existence of two distinct jurisdictions, there exists 1. Those who are lawful U.S. taxpayers who owe the tax to the national government, and 2. Those who have no liability for the federal income tax whatsoever and are lawful non-taxpayers. In the latter group, we find the vast number of American nationals who live and work in the private sector and have no financial or territorial connection with the national government. You can locate another document in our Resource Center that illustrates this fact made by a federal appellate court. In Economy, Plumbing, and Heating versus the United States, you will find stated the following. Revenue laws relate to taxpayers and not to non-taxpayers. The latter are without their scope. No procedure is prescribed for non-taxpayers, and no attempt is made to annul any of their rights and remedies in due course of law. Perhaps a clear restatement in everyday terms might help those who are not used to legalese speak from those who are skilled in the practice of law. With that purpose in mind, and with no intention to alter or skew the context of the statement made by the Federal Appellate Court, one might find that the following overview to be of greater clarity. The revenue laws found within the Internal Revenue Code only relate to U.S. taxpayers, and those statutory laws only applicable within the limited territorial jurisdiction of the national government do not relate to non-taxpayers, who are American nationals living and working in the constitutional republic, who have no financial connection with the national government. Therefore, the non-taxpayers are not within the scope of application for the revenue laws that are published in the Internal Revenue Code. No procedure or laws are prescribed or created that would ever apply to those who are lawful non-taxpayers, and no agency or bureau of the national government shall be able to attempt to annul any of the unalienable rights of American nationals protected by the U.S. Constitution by presumption or pretense from those statutory laws which do not apply within the constitutional republic. So, you should be able to now see at this point that there are two distinct jurisdictions that exist from the creation of the U.S. Constitution, and that some laws or acts of Congress do apply toward the constitutional republic, but a vast majority of them only apply within the limited territorial jurisdiction of the national government, the District of Columbia and its territories. You also should now recognize that there are two distinct groups in regard to the federal income tax. Those are U.S. taxpayers, and the others who are lawful non-taxpayers. Only those U.S. taxpayers who do not pay their tax obligations can ever be labeled with the terms tax cheats, tax evaders, and tax protesters. By now you may be asking yourself, well, who are U.S. taxpayers? There are basically 6 different groups who make up U.S. taxpayers, being referenced by the Federal Appellate Court. 1. Those who work for the national government or the District of Columbia by holding a public office as a federal employee, officer, or elected official of the national government, the District of Columbia, and other federal instrumentalities. This is perhaps most clearly illustrated by the statute at 26 U.S.C. Section 6331A, where a levy can be imposed if they fail to pay their tax obligations originating from federal employment as listed in this statute subsection. 2. U.S. persons. This group is defined at 26 U.S.C. Section 7701A30, which includes those who are referenced by the statutory term U.S. citizen. The term U.S. citizen is defined at 8 U.S.C. Section 1401A to mean a person born in the United States and subject to the exclusive jurisdiction thereof. An even more descriptive definition is found at the American Journal of Jurisprudence, section 2689, who is born in the United States and subject to the United States jurisdiction. Here you will find it references, quote, "A person is born subject to the jurisdiction of the United States for purposes of acquiring citizenship at birth, if his or her birth occurs in territory over which the United States is sovereign." 3. U.S. resident alien individuals. This refers to those who move to either the Constitutional Republic or the District of Columbia, U.S. territories, to live and work. You can learn more by reading 26 CFR section 1.871-1A about their tax liability. 4. Those who derive income and profits from the use of federal property within or without the jurisdiction of the national government. This is explained at 26 U.S.C. section 861A. 5. Non-resident alien individuals who choose to live and or work in American Samoa or Puerto Rico. And 6. Non-resident alien individuals who made a willful and knowing voluntary election to have their earnings taxed like that of a resident alien. The last clarification needed for background is that of the somewhat confusing term non-resident alien individual. A definition for this term is a good starting point, so you can find this definition provided in the IRC at 26 U.S.C. section 7701B1B. This subsection states, "An individual is a non-resident alien if such individual is neither a citizen of the United States nor a resident of the United States." If you look up the definition of the word definition, you will see that this expression at 26 U.S.C. 7701 does not fit the proper use of a definition. By this subsection, you only learn what a non-resident alien individual is not, rather than what a non-resident alien individual actually is. If someone were to describe the paint color on the walls in their home and said, "My wall color is neither white nor red," would you know what the color of the walls actually was? Of course not. But we do know two things about a non-resident alien individual. 1, they are not a citizen of the United States, and 2, they are not a resident of the United States. Knowing that some terms, especially those used by the national government, the U.S. Congress, have unique meanings that do not fit the everyday meanings used by most American nationals, we need to find the definition of citizen of the United States and United States, so that we do not make any presumptions as to what the meanings actually are intended to mean by their creator, the U.S. Congress. As we discuss this very important expression, non-resident alien individual, created by the U.S. Congress, we will also use some graphical representations to hopefully make the information more understandable. As you can see from this world map, all the nations of the world have people constantly on the move. In context of the U.S. Congress term non-resident alien individual, all people who do not live within the Constitutional Republic or the District of Columbia and its territorial states are non-resident in a geographical sense and are certainly alien to all federal tax laws. Thus, the U.S. Congress could not have been referring to those people in other nations that have no domicile within the landmass referred to as the U.S. So, the term non-resident alien individual does not describe those people in other nations who have no nexus with the USA. Now, if people from other nations choose to obtain a visa to enter the U.S., seek employment, and create a domicile in the U.S., then that is a different situation. Those who chose to do this are called U.S. resident aliens, and of course are not non-resident alien individuals. They become U.S. taxpayers by their own free will choice to request the privilege of living and working as a foreigner in the geographical USA. As mentioned earlier, we have seen what a non-resident alien individual is not. They are not resident aliens, and they are not U.S. citizens as expressed by the U.S. Congress. You can find the definition of the statutory term U.S. citizen or citizen of the United States at 8 U.S.C. section 1401A, which states, "A person born in the United States and subject to the jurisdiction thereof." So, this term is nowhere to be found in the IRC, and you see the linking of two more components in the definition. Those two phrases are born in the United States as well as subject to the jurisdiction of the United States. This is getting pretty complex, but stay with us as we're about to bring this all together. In the American Journal of Jurisprudence, section 2689, who is born in the United States and subject to United States jurisdiction, you find stated in part, a person is born subject to the jurisdiction of the United States for purposes of acquiring citizenship at birth if his or her birth occurs in territory over which the United States is sovereign. Everyone living and working within the District of Columbia and its U.S. territories are not non-resident alien individuals, as the U.S. Congress has defined those who live in that jurisdiction to be U.S. citizens or citizens of the United States. This indicates that this definition of citizen of the United States or U.S. citizen is far different from the expression used in the U.S. Constitution. The national government is not our sovereign, but it is a sovereign in its own limited territorial jurisdiction. We know from Yick-Wo versus Hopkins that the Supreme Court stated in part, sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts, and the law is the definition and limitation of power. This is a clear reference to the fact that American nationals are the sovereigns, as stated by the U.S. Supreme Court, which is an indication that the national government, the statutory United States, is a sovereign in some other place. That other jurisdiction is the District of Columbia and its U.S. territories, and does not include the constitutional republic, the 50 states. We purposely avoid using the term sovereign, as it today creates controversy when presented to the national government, and thus we only mention it because the Supreme Court referred to that term in context to American nationals. Now we need to define the term United States, as it was a term used in the definition at 26 U.S.C. section 7701b1b. One can locate the definition of the statutory term United States at 26 U.S.C. section 7408d. This definition shows that the reference to United States within the IRC, unless stated differently by the reference to the 50 states of the Union, only means the District of Columbia. 26 U.S.C. section 7408d expresses the meaning as follows. If any citizen or resident of the United States does not reside in and does not have his principal place of business in any United States judicial district, such citizen or resident shall be treated for purposes of this section as residing in the District of Columbia. So now, when you hear or see the expressions citizen of the United States and United States used by those in the national government, you are aware that they are describing those who are subject to their jurisdiction, which they call the United States, but in reality are only referring to the District of Columbia, unless they specifically refer to the 50 states of the Union, which is quite rare in context of the federal income taxation question. As to the definition we began with at 26 U.S.C. section 7701b1b, you know that a non-resident alien individual is not one who is subject to their jurisdiction, nor one who was born in the territory belonging to the United States or the District of Columbia. A resident alien is obviously not a non-resident alien, so that eliminates them from consideration. We are still left with finding out just who a non-resident alien individual actually is, and we will start on that momentarily. This is the only remaining source of people who just might be what the U.S. Congress has expressed in the term non-resident alien individual. Where else can they come from after all the other options have been exhausted? Just from a graphical sense, we see that this is the last group that could possibly be considered as non-resident alien individuals, and they must be non-resident to the jurisdiction of the national government, represented by the U.S. Congress statement. They must also be alien to the legislative jurisdiction of the national government, or else the federal income tax would have included them as being subject to their jurisdiction. For this to be truly stated and a statement of the truth, you need to know that a non-resident alien individual is not liable for the federal income tax, and that makes the journey to identify who they really are more important. The regulation at 26 CFR section 1.871-1A states in part, non-resident alien individuals are taxable only on certain income from sources within the United States, and on the income described in Section 864C4 from sources without the United States, which is effectively connected for the taxable year with the conduct of a trade or business in the United States. Hopefully, you remember what the definition of United States was defined to mean at 26 U.S.C. section 7408D. If you did, you are getting the information process in this paradigm shift very quickly. Only the District of Columbia, not the 50 states of the Union. Now there is the mention of a new term, the trade or business phrase that is statutory in nature. We cannot afford to stop checking definitions when we see new words. Would you look at how many terms you have to define? It does get overwhelming at first, but stay with us. We will make short work of the statutory term trade or business and then move on. You can locate the definition of a statutory trade or business at 26 U.S.C. section 7701A26, which is stated the term trade or business includes the performance of the functions of a public office. Only those who work for the national government hold a public office that was created by the U.S. Congress. To paraphrase the term trade or business, it means that which consists of, to the exclusion of all other terms, those who derive their income from the performance of the functions of any type of federal public office created by the U.S. Congress. Thus, the paraphrased version of 26 CFR 1.871-1A states in part, non-resident alien individuals are taxable only on certain income from sources within the District of Columbia, and on the income described in Section 864C4 from sources without the District of Columbia, which is effectively connected for the taxable year with the conduct of a trade or business in the District of Columbia. So, if a non-resident alien individual does not derive any income from the performance of the functions of a public office within the national government, the District of Columbia, or their instrumentalities, then that non-resident alien individual has no taxable liability. They are without the jurisdiction of the national government and earn their living with no nexus to the national government's jurisdiction or property controlled by the national government. Remember the jurisdiction for the application of the federal income tax? You guessed it, the District of Columbia. Do you also remember upon whom the federal income tax was only levied, as stated by President Taft? Now I think you have it. Only those who work for the national government. This is really getting exciting. Hope you're seeing what the federal tax laws are telling you. Now we can turn to another federal publication, Federal Retirement Thrift Investment Board. This is not the most current version of this document, but it does tell you the facts that pertain to our discussion, and nothing has changed about tax liability as the 16th Amendment has not been altered or modified. It states, a non-resident alien is an individual who is neither a U.S. citizen nor a resident of the United States. Do you remember what a statutory U.S. citizen was defined to mean at 8 U.S.C. section 1401A and at AMJR section 2689? Hopefully this isn't spinning your mind, but if so, just hit rewind. On page 2 of this document, you see the question number 1, do I owe U.S. taxes on a payment from the TSP? It states, the Internal Revenue Code governs your tax liability and withholding responsibilities. No confusion about this statement, so we move forward to another section. On the right column on page 2 of this federal document, you see the statement, a non-resident alien participant who never worked for the U.S. government in the United States, the District of Columbia, will not be liable for U.S. income tax. Can you believe that statement? Well, you don't have to believe it, as it is published in bold letters on this federal document for all to see. But it goes on with even more details. A non-resident alien beneficiary of a non-resident alien participant will not be liable for U.S. income tax if the participant never worked for the U.S. government in the United States, the District of Columbia. You might be thinking like we are in that, could it be possible that the U.S. Congress is actually talking about American nationals within the 50 states of the Union? With all this excitement, we must continue to press forward to learn more about those who are non-resident alien individuals being referred to by the U.S. Congress. We continue with the regulation published at 26 CFR section 1.871-1A, where we read, however, non-resident alien individuals may elect under section 6013G or H to be treated as U.S. residents for purposes of determining their income tax liability under chapters 1, 5, and 24 of the Code. How are U.S. residents treated, you ask? As U.S. taxpayers. Any non-resident alien individual who makes a voluntary election under section 6013G or H becomes a U.S. taxpayer. Do you have any idea how a non-resident alien individual makes an election? By filing their first Form 1040 U.S. individual income tax return is how. When they do that, they join the U.S. Tax Club and each year donate their hard-earned income in huge proportions to the national government. Plus, as an auto-renewing membership, they continue to participate and are not treated like who they are, but as one who is a U.S. resident alien. A U.S. resident alien has no protections under the U.S. Constitution or unalienable rights as do American nationals, so keep that in mind as we go forward. Are you now ready to learn who the U.S. Congress was addressing by this obtuse term, non-resident alien individual? If you're not sitting down, please do so. We now turn to 26 CFR section 1.871-1B4, expatriation to avoid tax. This regulation subsection pertains to the topic we've been discussing for some time now. Here's what is stated as it applies to expatriation to avoid tax. For special rules applicable in determining the tax of a non-resident alien individual who has lost U.S. citizenship with a principal purpose of avoiding certain taxes, see Section 877. Well, we know that a non-resident alien individual is not a statutory U.S. citizen who is subject to the jurisdiction of the national government by birth and territory belonging to the national government. We also know that a non-resident alien is not a resident alien. We know that those who are non-resident alien individuals have no U.S. income tax liability unless they work for the national government or the District of Columbia in some capacity. Those who are property of the national government have no rights to expatriate, as the U.S. Constitution is not law within the territorial jurisdiction of the national government. Now we know that non-resident aliens can expatriate or leave the jurisdiction other than the territorial jurisdiction of the national government. They must have constitutional rights, and in order to lose their U.S. citizenship, they must have been born in one of the 50 states of the Union. Therefore, those who are listed in federal tax laws as non-resident alien individuals are American nationals who have protections against the intrusion of the national government into their lives. They are protected by the U.S. Constitution. They enjoy unalienable rights. They are the only ones who can expatriate from the constitutional republic, and by doing so, lose their constitutional U.S. citizenship. The term non-resident alien individual is addressing you, if you were born in one of the 50 states of the Union or naturalized there. This is why the 13th Amendment is so powerful for you. The national government cannot compel any American national to associate with it, just like Alexander Hamilton stated. Slavery and involuntary indentured servitude have been abolished in the 50 states of the Union, the constitutional republic. That is not the case in the territorial jurisdiction of the national government, because the U.S. Constitution is not law within their territorial jurisdiction. American nationals, non-resident alien individuals as the U.S. Congress refers to us, have no federal income tax liability as confirmed by former President William H. Taft and in the creation of the 16th Amendment. For the national government to impose a direct income tax without addressing the rule of apportionment means exactly what the Supreme Court stated. Such an act would be unconstitutional. However, if you did once file a Form 1040 U.S. individual income tax return, you made the voluntary election under 26 U.S.C. Section 6013G or H to allow the national government, via the IRS, to treat you as if you were a U.S. resident alien. They could not treat you as an American national because the federal income tax is unconstitutional if attempted to be applied toward Americans who do not work for the national government or derive income from property belonging to the national government. Take a few moments to cool down and catch your breath. While you're doing that, did you know that the U.S. Department of the Treasury states in 31 U.S.C. Section 321 D1 and D2 that the federal income tax is a gift or bequest made payable to and for the use of the United States, meaning the national government? A gift or bequest is not a mandatory obligation. That is why 26 CFR Section 1.871-1A stated, however, non-resident alien individuals may elect, under Section 6013G or H, to be treated as U.S. residents for purposes of determining their income tax liability under Chapters 1, 5, and 24 of the Code. Look at the word may. Is that an obligatory word or a permissive word? You got it correct if you said permissive. The U.S. Congress is telling you that you may, with their permission, join their U.S. tax club and pay annual dues for the rest of your life at the tune of between 25 to 40% of your annual income for them to enjoy as a gift or bequest to and for their use as to how they will spend it. How has this paradigm shift caused you to react? You can't even sue the national government because they told you that it was a voluntary act on your part to join their U.S. tax club. You made the free will choice is what they will tell you. I know you didn't read the fine print, or maybe you never knew where to look, right? What do they care? It was up to you to know the law and for you to make the choice to volunteer to participate or not. Remember, this is your choice to stay involved in the U.S. tax club if you so desire. However, you may leave the U.S. tax club at any time you desire, and you can never return to that club according to 26 U.S.C. Section 6013 G6, only one election. What do you do with the information you've just learned? That's totally up to you, as you're a free moral agent. You will be responsible for your decision. So we now ask this simple question to you, the viewer. Do you still wish to participate in the U.S. tax club? If your response is yes, then you should leave this video right now. We also ask that you never return to our video or to our website, as our information is not pertinent to your situation. You must be one who is a U.S. taxpayer, and we do not want, nor will we ever interfere with those who choose to participate in the U.S. tax club and be taxed like that of a U.S. resident alien. It is your choice and no one else's. For those who are American nationals and choose to leave the U.S. tax club as provided by the U.S. Congress, we can continue our video discussion with you without any apprehension or concern in violating any federal laws. Now that the background has been covered, we move forward with the discussion about the revocation of election. This pertains to those American nationals who, 1, willfully and knowingly made a voluntary election to allow the National Government Bureau, the IRS, to tax their earnings like that of a U.S. resident alien. It also applies to those American nationals who, 2, may have made a voluntary election via a sub silentio process, meaning without knowing and willful intent of their action of election, and perhaps made the election based on social convention. The national government cannot compel American nationals to associate with it. That would be in direct violation of the 13th Amendment, which outlawed slavery and involuntary indentured servitude within the constitutional republic. An election is defined in Webster's dictionary as the right, power, or privilege of making a choice. Black's Law Dictionary defines election in part to mean the internal, free, and spontaneous separation of one thing from another, without compulsion, consisting in intention and will, the choice of an alternative. Please remember that this is created as your option by the U.S. Congress and not us. 26 U.S.C. Section 6013 G has a header with the following statement. Election to treat non-resident alien individual as resident of the United States. At this point, you know clearly who a non-resident alien actually is, an American national. 26 U.S.C. Section 6013 G4, Termination of Election, states, an election under this subsection shall terminate at the earliest of the following times. This subsection 6013 G4A, related to revocation by taxpayers, reads, if either taxpayer revokes the election as of the first taxable year for which the last day prescribed by law for filing the return of tax under Chapter 1 has not yet occurred. At 26 U.S.C. Section 6013 G6, only one election, you find stated by the U.S. Congress, if any election under this subsection for any two individuals is terminated under paragraph 4 or 5 for any taxable year, such two individuals shall be ineligible to make an election under this subsection for any subsequent taxable year. This shows you that any American national can choose their path to leave the U.S. tax club immediately if they so desire, and cannot be compelled by the IRS to continue participation in the U.S. tax club against their will. The 13th Amendment provides you with that benefit of sleeping well if you elect to terminate your former election. It has taken Weiss+Associates a few decades to uncover this tremendous exit door provided by the U.S. Congress. Our documentation is robust and has already served a large number of American nationals. For more information on our revocation of election process, please go to our website, Weiss+Paris.com, and if you're ready to move forward with the option the U.S. Congress has provided you, then respond to each of our 8 strict criteria listed at the top of the Revocation of Election section, which can be accessed from our homepage. We look forward to hearing from you soon if you decide to move forward with the revocation of election process we have perfected. Thanks for watching, and please subscribe to our channel while you're here.